desktop, I think. Yeah, I'm already live on here.
All right,
Um,
don't screw that up because I'm not getting back up to help you.
can that hear me well? I don't.
Yes, it can. It hears you just fine. Just don't touch it. Lord. And
Listen.
keep that light on instead of this one.
Yeah, that's why I
It's the
switched it.
bathroom side.
You have to
Okay,
move more.
okay. You're on live. You can't
Uh-huh.
talk about that now.
Okay. All right, where we at here? Chapter 7. I hope my voice is coming through clearly on the YouTube. Well, we are starting chapter 7, The Art of Passing the Buck. And what I'm gonna do is read the sections and then stop and see if there's any questions on there. Do my little opinion or whatever of the reading, and then we're gonna go right through. All right. Chapter 7. Let me take this off. Chapter 7. The application of wills and trust. Even though the previous chapters have given you the broad strokes of wealth and the philosophy of sorry. Third. Even what's wrong, babe?
You like it?
Yeah.
Okay, I'm just telling you, your dinner's done. So when you finish, you'll be good.
Okay. Can I just do it in there?
Huh?
I can't just do it in there?
Do the live in the living room?
Yeah.
You can if you want, but you always have it here. Don't start moving stuff around. You can't hold everything together. That's multitasking.
All right.
Just go ahead and read.
But I'm hungry now, though. All right. Where was that? Even though the previous chapters have given you the broad strokes of wealth and the philosophy of riches, we now want to bring you back to chapter 1, where lack of foresight caused great grief. It is a cautionary tale concerning a common situation that results in the careless dissipation of wealth, one we deliberately place prominently up front to shatter your complacency and seize your attention. Now that you have seen the long range results of how a trust can work for the good of a group, you can see the true cost of failing to plan properly for your family. It is too late to do anything once you're gone. Now that you have a vision of possibilities, it is time to lay in your dream. It is time to lay in your dreams, but what to do and what not to do. The typical solution of will deficiencies is the next section. The typical solution to pass along your wealth has been a will. Some financial reports advise that annually, as much as 53% of Americans die. Okay, I'm sorry, let me read that again. Okay. Sorry about that. Let me just read that whole section again. A typical solution to pass along your wealth has been a will. Some financial reports advise that annually, as much as 53% of Americans die intestate, that is, without a will, leaving their estates and thus their descendants to the not so tender mercies of the probate court. This is where blood is only sometimes more important than marriage, where the state and federal tax authorities get to take big bites, where creditors get their money, where fees get paid for, um, court-appointed executors and the like. Asset payout comes only after a great deal of time and according to the state-mandated prioritized list of recipients. Sadly, even having a will does not solve the problem. All it takes to contest even the most carefully drafted will is one aggrieved person or another party, such as a charity named in the will, to dispute anything from a minor clause to whether or not you were even sane when you wrote it. Thus, this challenge puts your estate into probate court, where the wrangling can continue for years, sometimes to the limits of human and legal bill paying endurance. The living trust is not exempt from this flaw. Although it can get around probate, it is treated the same as a will if contested. Meanwhile, your estate's assets remain frozen. Also, also true if you die intestate, leaving your descendants with nothing until matters are I'm sorry. Meanwhile, your estate's assets remain frozen, also true if you died intestate, leaving your descendants with nothing until matters are finally resolved. It was precisely to address this and other problems that trusts were created. When properly constructed and administered, they provide you with maximum say over to whom your estate goes and how, while maximizing privacy, protecting the estate, and minimizing the tax bite. Some forms of trust are more effective in providing these benefits than others, but all offer major advantages over the usual will. If you did not read all of chapter 2, which we did, I don't know why it's telling us that. Um, this is probably a good time to go back and read divided title in the United States Constitution, along with the legal definitions concerning trust in general. Okay. All right, so that's the end of this section. So far, let's see. Okay. The title of this was application, right? And I remember one of my critiques yesterday was that very thing. Like, when are they going to get to the application? So I'm going to withhold my comment. I'm just going to keep reading. So we already know, because we did not skip when it asked us earlier when we were reading, and it said, if this is going to be boring to you, go ahead and skip. We did not do that. We read the whole thing. And the divided title, and it's just my opinion of the reading. This is not no type of advice or nothing like that. Um, from what I gathered from what it was saying about the divided title is that the title holder at one time, based on English history and law, the title holder was the person that could be basically attacked financially. If you have something, if you're holding something, then it's easier for, in their case, when they were talking about the king, to come swoop up your wealth. So they devised this divided title, which is you don't actually own the thing, but instead something else is running it for you at your behest and at the behest of beneficiaries. And therefore, you actually don't own anything, or you own very little. Um, this was what they were telling us in the beginning. So that was the divided title. And then also the US Constitution. So this is the second time that they've referred us back to the US Constitution vaguely. That's a red flag for me, because that document is a standalone document, right? So it's just like the Bible. If you're referring to it, you got to do more than just say, in the book. It's a lot of book there. You got to be a little more specific than that, right? So that's just that's where I'm at so far with this chapter 7. But we'll keep going. We'll see what more they have. Um, let's see. What more do I need to know about a trust? Is the next section. In its simplest form, a trust is a legal entity created when you, known as the grantor, transfer ownership of a property of personal property to a trustee or trustees for the benefit and support of a named party or parties, the beneficiary or beneficiaries, according to the terms set forth by you in the legally binding trust indenture. These are two basic types of trust. There are two basic types of trust: revocable and irrevocable. Okay, I forgot to silence the phone. Um, what was that? There are two basic types of trust: revocable and irrevocable, with many variations on each. As explained in Chapter 2, in a revocable trust, you become the trustee and the main beneficiary. You can change the provisions of the indenture until you die. But, excuse me, but whatever the final version becomes, unless there is some gross legal defect, it is cast in concrete upon your death. It cannot be changed thereafter. Thus, a revocable trust becomes irrevocable. There is a big tax catch here. If if ownership of your estate does not change until you die, then while alive, you bear the burden of all the requisite taxes. In other words, personal control equals personal tax liability, cast in stone. In an irrevocable trust, though, as soon as you sign and witness the carefully thought out trust indenture, for good or ill, not only are you committed, but likewise your trustee or trustees and the beneficiary or beneficiaries. Okay, I read that wrong. Let me read that again. Sorry. Uh, in an irrevocable trust, though, as soon as you sign and witness carefully through the carefully thought out trust indenture, for good or ill, not only are you committed, but likewise your trustee and trustee and the beneficiary or beneficiaries. Once the trust is funded, there is no turning back. And from this point on, while you have the use of some or many of the assets, you will not own them and cannot be taxed for them either. Why? They no longer belong to you. They not only belong they not only belong to the trust, but are insured, maintained, and if necessary, guarded by the funds generated from the trust. While alive, you can enjoy some of the benefits of ownership with none of the hassles, while saving big on taxes and safe in the knowledge your estate will never be tied up in probate court. Why? Probate court has no jurisdiction over an irrevocable trust if it is properly drawn. And they give us a footnote. Appendix A. The history of the word jurisdiction is presented to mean the place where one has sworn allegiance. In our current political atmosphere, it generally means the place where one agrees to the laws. Okay, that is in Appendix A. So they're defining for us jurisdiction. All right, but the fact that they made a footnote right there, that makes me pay attention to that. So the probate court has no jurisdiction over an irrevocable trust if it is properly drawn. See, a wise man once said, if is a little word with a big meaning. I'm going to read that again. Probate court has no jurisdiction, and they include the footnote for jurisdiction, meaning the current, uh, the place where one agrees to the laws. So probate court has no jurisdiction over an irrevocable trust if it is properly drawn. Who decides if it's properly drawn? First question in my head. Who decides that? Because if jurisdiction means agree to the law, then that means the law is going to decide whether my trust is properly drawn up or not, which is the court, which goes back to this whole thing of this being somehow untouchable. This is not untouchable. It's just not. And they're telling you right here, if you're paying attention, they're telling you that. So next, my next question, Mr. Charles, how do you properly draw up a trust? How much I want to bet we'll get through this whole book without answering that question? Ah, man. But we're going to read it anyway. Let's go. Figure 2 in Chapter 2 depicts a generalized irrevocable trust structure. It shows the key players together with a few of the many potential income streams available to it. The permitted income streams in your trust, though, will be a function of what you specify in your trust indenture. Breaking it down. Your trust begins with you, the grantor. For this example, we assume that the initial corpus, literally the body of the trust, consists of $250,000 plus your $250,000 whole life policy and say another $100,000 in mutual funds. Okay, so let's just do some simple math here. Sir, Mr. Charles, that's $600,000, Mr. Charles. Are you telling me that? See, this is what I be talking about. This is the book is called The Art of Passing the Buck, and it says secrets. You telling me to start with $600,000? That's not a secret. That's just money. But again, this is what I mean when I say read it, yes, but critique what you read. All right. If it's good, it's good. You don't even have to worry about it. You'll be able to use it like anything else. You know what I'm saying? It's a good tool. But if it ain't giving you something that you can use, critique what you're reading. All right. So they said the trust begins with me and my $600,000, a quarter of it, a quarter of a million being cash or just value of 250,000. And then another quarter of a million is a whole life policy. Okay. Okay. And then another 100,000 in mutual funds. Okay. Depending upon the trust type, the corpus, which forms the assets of your trust, can come into being during your lifetime or through a will that automatically comes into being when you die. This is a testamentary trust. Either way, trustees administer the corpus and must increase the value of the trust, follow the terms of your trust indenture, determine investments, where to put trust money and or assets to generate revenue, administer distribution, how much of the profits can be shared with beneficiaries, properly handle accounting to retain enough funds to cover expected administration expenses, keep enough funds to increase investments. Meet and converse with the beneficiaries to ensure their needs are met in accordance with your wishes. This emphasis on generating revenue from investments is no accident. Diligent trustees are all about growing the corpus. The more the trust makes, the more they make. Trustees, with the exception of the grantor, who usually acts as a trustee of a revocable trust, are paid a fiduciary fee based on a percentage of distribution. Through receiving a fiduciary fee, a trustee makes money if the trust makes money. If the trust loses money, the trustee receives either no money or much less money. The idea is to motivate the trustee to bring in a sufficient cash flow for the beneficiaries. There are many issues, though, about what is considered acceptable risk and what trustees should and should not do. These are addressed in the probate code. This body of case law can be an excuse for the trustees to be fearful to take risk. Recently, laws were passed to encourage trustees to increase the value of the trust for the beneficiaries. Let me read that again. All right. Recently, laws were passed to encourage trustees to increase the value of the trust for the beneficiaries. There are private trust contracts that can encourage trustees to take greater risk, but those will be handled later in this book. Remember, your trust indenture must be written to provide not just your trustees, but their successors with clear-cut guidance on A, your intent, and B, what are and are not acceptable investments. It may seem a little spooky, but in a sense, you will eventually reach a point where you speak from the grave to those entrusted with caring for those who are dear to you and advancing the causes you cared about during your lifetime. Oh, that was the end of chapter 7. Okay. All right. So recap. Let's look back. Let's look back. Chapter. Okay. This. All right. Chapter 7. Chapter 7 was called The Application of Wills and Trust. If you are listening, or if you're listening on the TikTok, or later if you're listening to this as a recording, this is the question I have for you. After reading that, or listening to that, if you're listening to me afterwards, right? Was there something in that chapter that you saw that fit this title, The Application of Wills and Trust? Because I'm trying to be patient with this book, but what application did I learn just now? I already know, you already told me, I'm 7 chapters in. I already know I have to get the trust. I got it. Got to make one. Okay. It's for me and my family afterwards. Awesome. Totally get that. Now, the how-to part has been evading me, though. And I'm on chapter 7. What's up? Like, what's happening? Where was the application? Are you telling me just that's almost like saying, the same thing twice, but saying it in a different way? You're saying, get one? Yeah, I got it. I'm okay. But where's the how? Mr. Charles, where's the how? All right, since we got through that chapter real quick, let's go through chapter 8. Let's see. All right, chapter 8 is it's 6:30, so yeah. Let's see. I gotta get. He's halfway through this one. Doesn't look that big. All right, here we go. Chapter 8. Trust not for everyone. You may be looking for answers because you are involved or embroiled in the issue of inheritance as a beneficiary or as a grantor. If you're thinking of setting up a trust, this chapter defines qualifications with emphasis on who should not put assets into a trust. If you are a beneficiary, if you are a beneficiary, you will learn some of the intricacies in setting up a legacy for future generations. Granted, the chapter title is provocative, but it nicely carries a key idea that is more. But it nicely carries a key idea that is marvelous as trust may some be for some. Certain types of trust may be ill-advised, harmful to even illegal for others. Well, they got away with commas in this book, man. The more the more complex and legally demanding the trust type chosen, the greater and more serious the funding restrictions and administration protocols. The irrevocable trust is by far the most demanding and restrictive, but in such rigors lie benefits attainable nowhere else. Often managed by lawyers, CPAs, or other professionals, the irrevocable statutory trust is compatible with current financial methodologies. If not managed by those licensed, then when the trustee may be in then the trustee may be an untrained family member who relies heavily on legal counsel. There also may be a court-appointed trustee. The irrevocable statutory trust is different from a private trust. At this point, we distinguish between the two. The irrevocable statutory trust comes in many different forms. See Appendix B for the list. Should we go look at that right now? Let me keep reading. I don't want to get confused by it, so let's just keep reading. So, okay, an irrevocable statutory trust comes in many different forms. Among legal professionals who specialize in trust, the various kinds listed are complex and involve sophisticated expertise. This book will not go into detail on each of the applications listed, as it is in your best interest to speak with a trust professional. At this point, we simply want you to understand the irrevocable common law trust is the most fully realized form of a trust when set up correctly. Further, until about 100 years ago, it was the most common trust used. We use it as a background and a point of comparison. Later in this book, we discuss the irrevocable common law trust in detail because we feel that all other types of trust evolved from this one. Once you understand this original, ancient, and sophisticated trust, you can more easily decide how to arrange your affairs. The following applies mostly to irrevocable trust and especially to the common law trust. When not to get a trust. Just about everyone is eligible to get a living trust. Managed by the grantor who becomes a trustee, you can put funds from any source into the bank account. After all, you are taxed on all the income that comes in your name, so the source only needs to be legal. Not everyone needs to have an irrevocable trust, and few are qualified. We will spend a significant amount of time throughout this book explaining the advantages of a trust, but sometimes in individual circumstances or capacity is not conducive to putting funds into an irrevocable trust. This is because funds coming into the trust must only be under the control of trustees. The following conditions compromise the trustees and create a complex tax position. Next page. Some of the hindering reasons include government wages, IRAs, W-2 wages, some retirement funds, professional licenses, doubters, excessive greed, and the criminally minded. Okay. Government wages. Government wages cannot be assigned to an irrevocable trust because when you have a contract with the government, you receive proceeds from the government. The government must write a check, and only you as an individual, the government must write the check only to you as an individual. Some researchers believe this is because the federal government is itself a trust, and the people are the beneficiaries. If this is the case, then only the named beneficiary may receive the funds distributed. Okay, so that's the second time, at least that I've caught it, where they've said that or alluded to the fact that our government is a trust, or our Constitution constitutes as a trust. All right. Where is that? I lost my place. Okay. The correct way to put assets into a trust is by filling out proper assignment documents, and the entity, business, corporation, partnership, which pays the funds recognizes the assignment and writes the check per the assignment. The government does not acknowledge any such assignment. Also, the trust is not the individual, quote unquote, entitled to the funds. This is because the government taxes the funds. And if the funds by assignment go to another entity, it is not likely to be taxed at the same steep rate it is for an individual. Usually, one of the significant motivators to assign assets to a third party is to reduce taxation and to protect it against lawsuits. If the government wrote a check to you for any benefits, this also cannot be assigned to an irrevocable trust. So, okay, that's the end of that section. So then my question would be, does that mean you can't put your SSI in a trust? Is that what he's saying? If it's, yeah, because it will be a trust account, right? Because they say you go in and you open the account in the trust name. So then that will be a trust bank account. Are we saying then that I can't put, if I have SSI or something like that, I can't put that into that account? Is that what it's saying? If the government wrote a check to you for any benefits, this also cannot be assigned to an irrevocable trust. Oh, I got it. The government is writing the check to you personally. That's what it is. This goes back to that idea of the divided title. When you hold stuff, things can get sticky. So be disconnected from the stuff. Basically, is the lesson here. Okay, let's see what they say. Independent and private contracts. Sometimes people have independent contracts with the government. Even these independent contracts cannot be rewritten and assigned to another entity. For example, Peter, a friend of yours, is an independent contractor. He repairs military Hummers. He then decides to get an irrevocable trust. Peter goes to the person with whom he created the contract and asks to renegotiate it to put it under a different name. the name of the trust. The government does not recognize this change, especially if the same person is doing the same work. The government might acknowledge the change if the contract were to be rewritten to a company and Peter was not part of the company. Oddly enough, the same rule applies to a contract with a corporation. The IRS challenges a change of a contract from an individual to a family trust. Okay. Some private retirement programs are trusts themselves and cannot transfer funds to another trust unless the program has survivor benefits. This means if the main beneficiary dies and benefits accrued to him, oops, let me read that again, sorry. This means if the main beneficiary dies and benefits accrue to him, the benefits may go to his heirs or to a named trust. W-2 wages. The employer deducts taxes from the employee and reports them on Form W-2. These wages cannot be assigned to an irrevocable trust. The employer pays taxes linked to a Social Security number. What the employee does with the funds is up to him or her. These funds can be received into an irrevocable trust. These funds can be received into a revocable trust, but not an irrevocable trust. An irrevocable trust must produce its own funds, and the trustees need to be solely in control of these funds. If the grantor of the trust puts his or her wages into the trust, then the grantor remains in control. The trust status changes from irrevocable to revocable, and the grantor becomes responsible for all the taxes in the trust. So again, they're saying try to keep space between, and this is my opinion of the reading. This is not no type of advice, no type of financial advice, nothing like that. But it sounds like what they're saying is keep space between you and the thing that you're trying to basically own. So that way you're not responsible for the taxes. That's what the last line was. All right, where did I go? 32. The proper way to arrange funds into an irrevocable trust is if, for example, Mary, a school teacher, wants to put money into a trust. She assigns her stock portfolio to the trust. By assigning the stock portfolio, the profits go directly from the stock account, now owned by the trust, into the trust checking account. Mary has no control over the money. Thus, she is not taxed. If Mary does not have an investment account, but still wants to start a trust, she can use her paycheck to invest into various opportunities, even offering a 10% APR loan to a friend. The friend then pays the trust. For an irrevocable trust to be independent and properly legally positioned, the grantor cannot control the trustees. Because of this, there is no advantage to putting W-2 wages directly into the trust. Okay. So let me see. Go for a break point here. Okay. Let's just review. That was the end of that section. Wages. I got very good. Okay. Professional licenses. Doctors, dentists, CPAs, and lawyers in some states can only work through corporations, LLCs, or partnerships. This particular ruling applies to California. When you use a corporation, you owe taxes to the state. Excuse me. And sometimes there is double taxation. When licensed professionals work through a trust, the beneficiaries pay the tax, often at a much lower tax bracket. Professionals can get a corporation though, and a trust can own some of the corporation's stock. Disorganized and confused. This is the next section. Hold on, y'all. I gotta something drink. Ah, all right. Where was I at? Okay. Disorganized and confused. Sometimes unorganized people want to get an irrevocable common law trust. Unfortunately, the disorganization and continual loss of significant paperwork arises after the trust is set up. Although this is a workable condition, these people must learn to become more organized because they work with a group of people who share a common goal. The chaos caused unsettles the entire group. If you're not paper oriented and not in a position to devote time and to understand the legal realities of this more sophisticated trust, then it may not be for you. Although, if you just want to give funds to a trust and walk away, wait. Although, if you want to give funds to a trust and walk away, not be involved, then this arrangement works to your advantage. All right. That was the end of that section. Let me see how much further I got. Yeah. All right. I'm gonna keep going. I'm not gonna think we're gonna finish chapter 8. You guys, it's got a little more to go. So what I'll do is I'll just keep reading until 7. See where we are by 7. All right. Where I lose myself. Okay. Poverty is the next section. People who live hand to mouth and do not have any savings are not candidates for any trust. Though contrary to popular opinion, you do not need to be wealthy. Okay, I read that wrong. I'm gonna read that again. People who live hand to mouth and do not have any savings are not candidates for any trust. Though, contrary to popular opinion, what the? Oh, all right. Okay, I'm sorry. I'm sorry. I gotta reread this. People who live hand to mouth and do not have any savings are not candidates for any trust, though contrary to popular opinion. You do not need to be wealthy. Those who are mostly without reserves and assets, though, make incredible beneficiaries, for they have great need and usually have gratitude which those born under certain circumstances may not have. The responsibility of privacy. Privacy is a core feature of many trusts. And demanding privacy, asserting your rights are learned. Sorry about that. Privacy is a core feature of many trusts. And demanding privacy and asserting your rights are learned behaviors. These simply do not come naturally. And excuse me, to most people. Only through mentoring can people learn to say no to a terrifying skilled interrogator. You will find more on this in chapters to come. They got to stop with that. They got to stop with this. It's coming up. It's coming up. It's coming up later. Give it to me now. I want to read it now. What are we doing? Why are you playing? All right. Yeah. Okay. If the most innocuous meeting with, hold on, let me just bigger my old Bibles. If if the most innocuous meeting with officialdom makes you break out in a sweat, and you're so spineless that you let people use you as a doormat, how are you ever going to stand your ground to keep your trust safe? You need to keep your composure and guard your tongue if confronted with professionally trained government intimidators, aka agents. After all, they fully expect you to offer no resistance whatsoever. Their quote unquote request are excuse me, their quote unquote quests are to be I say quest. Their requests are to be obeyed. Therefore, you should tamely accept whatever documents they may wish to serve you, as well as invite them in and show them whatever they may wish to see. The answer is obvious. You cannot. Therefore, if your natural instinct when confronted is to cower, roll over, and bare your throat, even with a even then even an irrevocable living trust may not be for you. Ooh, I'm tired, y'all. You must get beyond your own fears and think of the future of your beneficiaries. If you're not willing to do that, then do not get a trust. All right, I got like two more pages. All right, I'm gonna wrap it up here though. Um, oh, we still got. Oh no, we still got 9 minutes left. Yeah, we can keep going. We can keep rolling. I might finish this chapter. All right, let's go. Where we at? Pretend for a moment you are 15 years old and your father rifled through your bedroom while you were out on a date. Even if you had nothing to hide, this is a violation of your person, your space, and it displays a lack of trust. It is insulting and degrading. Your own paperwork can be used against you. Endless questioning can wear you down in your attempt to explain any little thing. Anyone associated with you may now become a target. If there is no evidence of criminal conduct, there is no reason to subject yourself to invasion of strangers. Trained in trickery, agents can make you feel guilty even if you've done nothing wrong. Why subject yourself to it? Make them get a search warrant. If they do not have enough evidence to convince a judge, then they have nowhere to go. They must leave you alone or continue to harass in hopes that you surrender some morsel. Of course, that leads to another morsel. Privacy is a major issue, from individuals to partnerships, corporations, and trust. All privacy issues are are sacred only if you know how to stop illegal. What is that? Oh, let me just read that again. Sorry about that. Read it again. Trust, from individuals to partnerships, corporations, and trust, all privacy issues are sacred only if you know how to stop illegal inquiries. Stopping illegal inquiries requires individuals and business officers to know their rights. People who do not know them have none. Okay, they're making some bold claims here. Okay, responsibility. Okay. I don't know. All right. Look, y'all, I'm gonna stop. It's 6 minutes early, but I'm gonna stop because I'm tired. So we got through chapter 7 was pretty quick, pretty easy. We on page 75 in chapter 8. So we will start there tomorrow. All right, let me look at this thing and see if I got any questions. Oh, I still gotta figure out how to put the people up there. That's the whole nother thing. I don't know how to do that with y'all yet. On on TikTok, I don't know how to do that yet. I'll figure it out though. All right, so yeah, y'all. I'm tired. So we did 7 and 8. We on page 75. Thanks for coming in. Appreciate y'all. I don't see any questions. Yeah, yeah, I don't see any questions. All right. Thanks for coming out. I will see you guys tomorrow, same time, the most high willing.